The Asian American unemployment has the lowest rate ever recorded. Women's unemployment recently hit the lowest rate in more than 65 years. Every U.S. metropolitan area saw per capita growth in 2018. Real wages have gone up by 8% for the low-income workers. Real median household income is now the highest level ever recorded. 40 million fewer people live in households receiving government assistance. We signed the biggest package of tax cuts and reforms in history. Since then, over $1 trillion has poured back into the U.S. 650,000 single mothers have been lifted out of poverty. We secured the largest ever increase for child care funding, helping more than 800,000 low-income families access high-quality, affordable care. We passed, as Manager Jeffries will recall, bipartisan criminal justice reform. Prescription drugs have seen the lowest price decrease, the largest price decrease in over half a century. Drug overdose deaths fell nationwide in 2018 for the first time in nearly 30 years. A Gallup poll from just 3 days ago says that President Trump's upbeat view of the nation's economy, military strength, economic opportunity, and overall quality of life will likely resonate with Americans when he delivers the State of the Union address to Congress next week. If all that is solely, in their words, for his personal and political gain, and not in the best interest of the American people, then I say, God bless him. Keep doing it. Keep doing it. Keep doing it. Maybe if the House managers stop opposing him and harassing everyone associated with him with the constant letters and the constant investigations, maybe we can even get more done. Let's try something different now. Join us. Join us. One nation, one people. Enough is enough. Stop all of this. Thank you.
Mr. Chief Justice.
Senator from Colorado.
Thank you. I send a question to the desk for myself and Senator Schatz and Senator Menendez.
Thank you.
We are listening. That was counsel for the president there. Quite emotional as he tried to dismiss this entire proceeding while talking in praise of President Trump, all the good he has done. That, of course, is not what's on.
The question from Senators Bennett, Menendez, and Schatz is to the House managers. If the Senate accepts the president's blanket assertion of privilege in the House impeachment inquiry, what are the consequences to the American people? How will the Senate ensure that the current president or a future president will remain transparent and accountable? How will this affect the separation of powers? And in this context, could you address the President's counsel's claim that the president's advisors are entitled to the same protections as a whistleblower?
Senate, privileges are limited. We have voted to impeach the president for, among other things, Article 2 of the impeachment is total defiance of House subpoenas. And the president announced in advance, I will defy all the subpoenas. What does this mean? It means there's no information to Congress. It means a claim of monarchical dictatorial power. If Congress has no information, it cannot act. If the president can defy, now he can dispute certain specific claims, you can claim privilege, etc. But to defy categorically all subpoenas, to announce in advance you're going to do that, and to do it is to say that Congress has no power at all, only the executive has power. That's why Article 2 is impeaching him for abuse of Congress. That's why, for much lesser degree of offense, Richard Nixon was impeached for abuse of Congress, for the same defiance of any attempt to by the Congress to investigate. But this is, and what are the consequences? The consequences, if this is to be, if he's to get away with it, is that any subpoena you vote in the future, any information you want in the future from any future president, may be denied you with no excuses. Announce in advance, I'll defy all the subpoenas. It eviscerates Congress and establishes the department, the executive department, as a total dictatorship. That's the consequences. Now, I want to also talk about, and the motives. The motives are clearly dictatorial. But I want to also take a point, since I have the floor, to answer a question, to comment on a question that Senator Collins and Senator Murkowski asked yesterday. And they asked about the question of mixed motives. How do you deal with a deed, with a president who may have a corrupt motive and a fine motive? And how do you deal with it? And Professor Dershowitz said, well, you have to look at you have to mix, you have to weigh the balances. Nonsense. Nonsense. We never, in American law, look at decent motives if you can prove a corrupt motive. If I am offered a bribe, and I accept the bribe for corrupt motive, I will not be heard in defense to say, oh, I would have voted for the bill anyway. It was a good bill. You don't inquire into other motives. Maybe you had good motives. But once the corrupt motive and the corrupt act was established, there is no comparison. All of this is just nonsense to point away from the fact that the president has been proven beyond a shadow of a doubt, and the defenders don't even bother really to defend. They just come out with distractions. He's been proven beyond a reasonable to have abused his power by violating the law to withhold military aid from a foreign country, to extort that country into helping his reelection campaign by slandering his opponent. Corrupt? No question. Violation of the law? No question. Factually? No question. They don't even make a real attempt to deny it. Everything is a distraction. And the one chief distraction is once you prove a corrupt act, that's it. You never measure the degree of maybe had decent motives too. So Professor Dershowitz, in talking about that, in talking about the absolute power of the presidency, was just absent from American law or any kind of Western law.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Georgia.
I sent a question to the desk for the President's Counsel on behalf of myself, Senator Ernst, and Senator Brasso.
Thank you.
Once again, we are watching the Senate impeachment trial as broadcast by C-SPAN, cspan.org, a nonprofit developed from cable television since 1979. You can always support C-SPAN at cspan.org. Do contribute money to C-SPAN and do try to help out. They're a valuable resource in a free society.
The question from Senator Perdue, Ernst, and Barrasso for counsel for the president is as follows. Please summarize the House of Representatives' three-stage investigation and how the president was denied due process in each stage. Combined with Manager Schiff's repeated leaks during the House's investigation, do these due process violations make this impeachment the fruit of the poisonous tree?
These are the questions, once again, put to the respondents by the senators. This one is to the president's counsel. And it'll be responded by, looks like, Mr.
Chief Justice, senators, thank you for that question. And the short answer, as I think I've indicated a couple of the times that I've been up here, is yes, this entire proceeding here is now the fruit of the poisonous tree. It is the fruit of a proceeding that was fatally deficient in due process from the start to the beginning. And as a result of that, it produced a record that is totally unreliable, can't be relied on here for any conclusion other than acquitting the president. And let me detail the three phases. First, the first error was that the House began the proceeding in a totally unconstitutional, unlawful, and illegitimate manner. It started an impeachment inquiry without any vote of the House to authorize that inquiry. And I want to spend a second on this because the House managers have spent a lot of time today trying to go back and argue about why their proceeding was all right, but they're not actually engaging the real issues. In order for the House to exercise the power of impeachment, there has to be a delegation of that authority to a committee. That's just a fundamental principle that the Constitution gives power to the House itself, not to individual members of the House, not to the Speaker. Just as here in the Senate, you wouldn't think that the majority leader could say, if an impeachment arrived, the majority leader could say, guess what? We're not going to do a trial with the whole Senate. I, the majority leader, am going to just decide that I'm going to have one committee, hear the evidence, provide a summary, and then you all can vote. The majority leader doesn't have the authority on his own to do that. The Speaker doesn't have the authority in the House to give the power of impeachment to any committee to start pursuing an inquiry. And this is the key. There is no rule giving any committee in the House the authority to use the power of impeachment. Rule 10 speaks of legislative authority, not the power of impeachment. And all the subpoenas that were issued came with letters saying on them, pursuant to the House's impeachment inquiry. They purported to be using a power that hadn't actually been delegated to the committee. That's the first flaw. Illegitimate, unlawful proceeding from the start. Then there are the due process flaws. 3 stages of hearings. 1, secret hearings in the basement bunker. President's locked out. No opportunity to cross-examine witnesses, to see the evidence, to present evidence. And then they go from that to the public hearings, what's really just a public show trial, because the president is still cut out, totally unprecedented in any presidential impeachment, that there would be that second phase of public hearings where the president is still cut out, can't present evidence. The minority members don't have equal subpoena authority. The third phase in front of the House Judiciary Committee, they purport to have offered rights, but I've explained that it was illusory because they had already decided before the president was supposed to respond with what rights he would like to exercise. The Speaker had announced the result. There were going to be articles of impeachment. The Judiciary Committee had decided they weren't going to hear from any fact witnesses. They had no plans for hearings. It was all a foregone conclusion because they had to get it done by Christmas. And the third error, that Chairman Schiff was in charge of all the fact finding. And he had an interest, because of the interactions of his office with the whistleblower that we still don't know about, to shut down questioning about the motive, the bias, the reasons that the whistleblower, how this all came about. All 3 of those errors infected this process from the very beginning. They resulted in a one-sided, slanted fact-finding that was rushed by a person controlling the fact-finding who had a motive to limit what facts would be allowed to get into the proceedings. And it produced a record that cannot possibly be relied on here. We've said many times, the Supreme Court has made clear that cross-examination is the greatest legal engine ever invented for the discovery of truth, and they didn't permit the president the opportunity to cross-examine anyone. And that's an indication that the goal was not a search for the truth. It was a partisan charade intended to justify a preordained result and to get it done by Christmas. And it's not a record that can be relied on here. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Illinois.
I send a question to the desk for the House managers.
Thank you.
We are listening to the Senate impeachment trial of Donald J. Trump, the 45th President of the United States of America. The senators ask the questions by writing them down. They're handed to a page. The page you see there takes it up to the Chief Justice, and the Chief Justice reads
The question from Senator Duckworth for the House managers. If the hold on aid to Ukraine was meant to be kept secret until the president could gather internal U.S. government information on Ukraine corruption and European cost sharing, then is there any documentary evidence of this? For example, is there any evidence that the president was briefed on those issues by the NSC, DOD, or State Department during the period of the hold in the summer of 2019, or any evidence that he requested specific information on anti-corruption reform measures in Ukraine? Prior to releasing the aid on September 11, 2019, did the president order any changes to administration policy to address corruption in Ukraine or burden sharing with our European allies?
Chief Justice. Thank you, Senator, for that question. Let's just take a moment and address what the process should have looked like. Because as we've already established and as President's Council has conceded and we've conceded, is this does happen, right? There is a legitimate policy process for review and for determination on hold, because there is indeed legitimate policy reasons to hold aid. And we've never said that corruption is not one of those, or burden sharing wouldn't be one of those. What we're saying is there's no evidence that in what we are talking about today, that the president was concerned or engaged that process. So what would normally happen is Congress would come together, as we did. We passed appropriations bills and we made a determination that funding was appropriate for the aid, which 87 members of the Senate did this past year. The president would then rely on the advice of government experts from the National Security Council, the Department of Defense, the State Department, and the Office of Management and Budget regarding that aid. That's the interagency process that we've talked so much about. The interagency process that we went through earlier last year. And at the conclusion of that interagency process, it was determined that it had met all of the conditions for the aid, and all the agencies determined that it should go forward. The president would then seek permission from Congress that he intended to, would normally, if there was a reason, the president would go back and seek permission from Congress to hold the aid. So let me repeat that. If there were a reason to hold it, the president, and President Trump has done this in the past under legitimate processes, as has President Obama and prior presidents, would go back to Congress under pre-described processes and make sure that they're not violating the Empowerment Control Act and seek permission to hold it. That did not happen. Congress would then weigh in on the request by either approving or denying the president's request. And then unless Congress specifically approves the president's request, the aid must be made available. Of course, none of that happened. In this instance, a hold was put in place. We don't know exactly when, because the president and his agencies have prevented us, and his council have prevented us from getting that information, but a hold was put in place. No reason was given. And in fact, the only one within the United States government who apparently knows why that hold was put into place is President's counsel, who tried to tell us last night why he thinks the hold was put into place, but nobody else knows. So yes, the answer is, if there was a legitimate policy process put in place, there will be a lot of information about burden sharing, about corruption, but any of the other concerns to which we have no evidence. And if burden sharing, to the last point of the question, was a concern, then the person who should have been asked to discuss those concerns with the EU and our European partners would have been Ambassador Sondland, because he is the United States ambassador to the European Union. And not once did President Trump go to Ambassador Sondland and say, discuss these issues with the EU and the Europeans, saying they need to provide more money. Not once did that happen. And it didn't happen because it wasn't the real concern. All of the evidence shows the president withheld taxpayer money, foreign aid to our partner at war, to coerce them to start a political investigation to benefit his 2020 election campaign. That is what the evidence shows, and that's why we are still here. And there is one person that can provide additional information on that, and that is Ambassador Bolton. And yes, it is still a good time to subpoena Ambassador Bolton.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Maine.
I send a question to the desk on behalf of myself and Senators Crapo, Blunt, and Rubio.
Thank you.
Again, we're covering the Senate impeachment trial. Senators are asking questions now.
A question from Senator Collins and the other senators for both parties. Are there legitimate circumstances under which a president could request a foreign country to investigate a U.S. citizen including a political rival, who is not under investigation by the U.S. government? If so, what are they and how do they apply to the present case?
That's an
The House
excellent
goes
question.
first.
That's an excellent question. That is the Chief Justice asking a question from one of the senators. The House is going to go first. They will be represented, it looks like, by Adam Schiff once again.
Mr. Chief Justice, Senator, it would be hard for me to contemplate circumstances where that would be appropriate. Where it would be appropriate for the President of the United States to seek a political investigation of an opponent. One of the, I think, most important post-Watergate reforms was to divorce decisions about specific cases, specific prosecutions, from the White House to the Justice Department, to build a wall. One of the many norms that has broken down under this presidency is that wall has been obliterated, where the president has affirmatively and aggressively sought to investigate his rivals. I cannot conceive of circumstances where that is appropriate. It may be appropriate for the Justice Department, acting independently and in good faith, to initiate investigation. There's a process for doing that. We heard testimony about that. You can make requests under the Mutual Legal Assistance Treaty, the MLAT process, when a foreign country has evidence involving a criminal case involving a U.S. person. There is a legitimate way to do that. That didn't happen here. In fact, when Bill Barr's name was first revealed, when that transcript was brought to light, the Justice Department immediately said, we have nothing to do with this. We have nothing to do with this. Here, this particular domestic political errand was being done by the president's personal lawyer. I wanted to just follow up also, while I can, Senator, on my colleague's comments in terms of mixed motives. If you conclude the president acted with mixed motives, some of them corrupt and forbidden, some of them legitimate, you should vote to convict. That principle is deeply rooted in our legal tradition. It is commonplace in civil and criminal law going back centuries. For example, in describing the standard for corrupt motive for obstruction, the Seventh Circuit rejected any requirement that a defendant's only or even main purpose was to obstruct the due administration of justice. Instead, the court explained, a defendant is guilty if his motives included any corrupt, forbidden goals. That case, the United States v. Cueto, which I cited earlier, is not only relevant here, but that case was argued by Professor Dershowitz, and he lost. He made the argument he's made and the president's lawyers have made today. They lost that case, and for a good reason. It's contrary to the history of our legal traditions. If someone, and this is the founders were concerned, for example, that a president might be charged with bribing members of the Electoral College.
Time was called.
Mr. Chief Justice, Senators, thank you for that question. I'd like to start by pointing out that the question sort of assumes that there is a request for an investigation in a foreign country of a United States person. I'd just like to bring it back, though, here to the transcript of the July 25th call, where President Trump didn't ask President Zelensky specifically for an investigation or an investigation into Vice President Biden or his son Hunter. I mean, there's a lot of loose talk and sort of shorthand reference to it that way. But what he refers to is the incident in which the prosecutor was fired. And the first thing that he says in that whole exchange is talking about the prosecutor being fired. And he says it sounds horrible to him. And the situation with Burisma. And so, and all that the president says is, so if you can look into it, it sounds horrible. It sounds like a bad situation. That's not calling for an investigation necessarily into Vice President Biden or his son, but the situation in which the prosecutor had been fired, which affected anti-corruption efforts in the Ukraine. And President Zelensky responded by saying, the issue of the investigation of the case is actually the issue of making sure to restore the honesty. So we will take care of that. And he's explaining that he understands that it's an issue that has to do with, was an investigation over there that their prosecutor was handling derailed in a way that affected their anti-corruption efforts, and it's something worth looking into. It's the president making clear that we're not saying that's off limits. It sounds bad to the U.S. as well. But let me get more specifically to the question, is there any situation where it might be legitimate to ask for an investigation overseas? Yes, if there was a conduct by a U.S. person overseas that potentially violated the law of that country, but didn't violate the law of this country, but there was a national interest in having some information about that and understanding what went on, then it would be perfectly legitimate to suggest this is something worth looking into. We have an interest in knowing about this, even if it's not something that would mean a criminal investigation here in the United States. And so that could arise in various circumstances where a person had done something overseas, but there was a national interest in understanding what they had done. Thank you.
The Democratic leader is recognized.
Mr. Chief Justice, I send a question to the desk for the President's Counsel and the House managers.
Thank you.
Chuck Schumer. Sounds like.
The Democratic leader's question is this. Yesterday, I asked the President's Counsel about the President's claim of absolute immunity. Specifically, I asked the President's lawyers to name a single document or witness that the President turned over to the House impeachment inquiry in response to their request or subpoena. Mr. Philbin spoke for 5 minutes and talked about the various types of immunities and privileges the President could invoke, but did not answer my question. So I ask once again, can you name a single witness or document that the President turned over to the House impeachment inquiry? It is directed to both parties, and President's Counsel goes first.
It's maybe too big, that's the problem.
Mr. Chief Justice, Minority Leader Schumer, thank you for that question. I apologize if I was not direct in getting to the nub of the question yesterday. I was intending to explain the rationales that the administration had provided for its actions and to explain, contrary to the question, that it was not simply absolute defiance and not simply a blanket assertion that we won't do anything. That's the way the House managers have tried to characterize it. But so let me be clear. There were document subpoenas issued prior to the adoption of House Resolution 660. The President explained, the administration explained in various letters, all of those were invalid, and there were no documents produced in response. There were no documents produced in response because all of those subpoenas were invalid. There was no attempt to reissue those subpoenas or to retroactively attempt to authorize them. There were then subpoenas for witnesses who were senior advisors to the President. The President advised the committees that had issued those, that those senior advisors had absolute immunity, and they were not produced for testimony. Those 3 senior advisors were not produced. There were then subpoenas for witnesses to others who the House managers, the House Democrats insisted they would be required to testify without the benefit of agency counsel. And I've explained that principle. The Office of Legal Counsel advised that those subpoenas attempting to require executive branch officials to testify without the benefit of agency counsel were unconstitutional. And so those witnesses were not produced. Still, there were 17 witnesses who testified, not including the 18th witness, the ICIG, whose testimony is still secret. So there was quite a bit of testimony, and there have been subsequently some documents relevant to this produced under FOIA. And I raise that because it makes clear that if you follow the law and you follow the rules and you make a document request that's valid, documents get produced. If you don't follow the law, the administration resisted. That's why the documents weren't produced, because the subpoenas were invalid, and we made that very clear. Thank you.
Thank you, Counsel.
Not a single document was turned over, not a single witness was produced, and the witnesses that did come came in defiance of the orders of the President. Now, Counsel has obviously made all these claims that we think are completely spurious, but what they don't answer is, what was the motivation to fight all the subpoenas? They argue this interpretation, which the courts have rejected, that have looked at it, that somehow these subpoenas were invalid. But why didn't they produce the documents? Why did they insist on this now discredited by courts legal theory? Because they were covering up the president's misconduct. Now, I want to return briefly to finish the comments I was making earlier about the senator's question earlier on mixed motives. There's a good reason why mixed motives are no defense. Otherwise, officials who committed misconduct could always claim that even if they did it, that even if it was corrupt, they must be acquitted because they were able to invent some phony motivation and insist it played some minor role in their scheme. Imagine how that principle would apply to a president charged with bribing members of the Electoral College. Multiple framers cited this specific threat while discussing impeachment at the Constitutional Convention. Could a president defend himself on the ground that he was motivated in part by a noble desire to reward members of the Electoral College for their public service? Could he defend it on the ground that even as he handed over the bribes, he wasn't just acting corruptly, but he was also seeking to advance the public interest by keeping himself in power? According to the president's lawyers, yes, he could. Indeed, for all the reasons we provided, there's no doubt that the president's quid pro quo was solicitation of foreign interference and his use of official acts to compel that interference were a fundamentally corrupt scheme, by which I mean the motive and intent was to benefit himself, to obtain personal political gain while ignoring and injuring core national interests in our democracy and our security. We have demonstrated we believe that the scheme was entirely corrupt. But if you have any question about that, ask John Bolton. If there's any question about whether the motive was mixed or not mixed, ask John Bolton. He has relevant testimony. You can ask also Mick Mulvaney. You can subpoena the documents and answer the earlier questions, what the documents say about when the president withheld the aid, whether there was any interagency discussion of reforms in the RADA. I mean, the president's counsel literally made the argument that the circumstance that changed was a change in the RADA. There is no evidence to support that idea.
Expired. The majority leader is recognized.
Mr. Chief Justice, I ask that we stand in recess until 4.
Without objection, so ordered.
So that will be the break in the action here in the Senate impeachment trial of Donald J. Trump, the 45th president of the United States of America. I have been covering it here. My name is Karthik Rajan. This is just a space I've created originally with an intention to cover the election of 2020 and in specific the mechanics of voting. How we go about voting, problems with digital machines, problems with voter suppression, problems with, how we're getting the count in, etc. And so that's at VCount 2020, Vote Count 2020, where I am tweeting out kind of as a compendium, just grouping at this point a variety of topics. I will be creating original content as the year goes on, but I haven't really gotten that into it. To be frank, the reason why I haven't really gotten that into it is that the impeachment has occupied me. And I have become very much absorbed, as you can see on my site here, with it. But I was thinking today about making a video in which we just watch a few videos. And while we're on a break from the impeachment hearings, I thought I'd play a couple of those for you. One of my great heroes is George Carlin. And Carlin passed away some years ago. But he makes a comment that's very clear. When we think about the senators who are not going to impeach Donald Trump, they will not, they absolutely will not. It was decided in advance before they walked into the building. And then when they took the oath of impartiality, they're going to break that oath. When we think about them, we have to be very clear about who they are and whom they represent. If you think they represent, some interest, like the evangelicals or the Southern blacks or some group of a particular kind of Republican, if you think they represent that, that's not the case. And many years ago, George Carlin was very clear. And now the people that they do represent, those people have their man in the White House. So let's take a listen to George Carlin on that.
Because the owners of this country don't want that. I'm talking about the real owners now. The real owners, the big wealthy business interests that control things and make all the important decisions. Forget the politicians. The politicians are put there to give you the idea that you have freedom of choice. You don't. You have no choice. You have owners. They own you. They own everything. They own all the important land. They own and control the corporations. They've long since bought and paid for the Senate, the Congress, the state houses, the city halls. They got the judges in their back pockets, and they own all the big media companies, so they control just about all of the news and information you get to hear. They got you by the balls. They spend billions of dollars every year lobbying to get what they want. Well, we know what they want. They want more for themselves and less for everybody else. But I'll tell you what they don't want. They don't want a population of citizens capable of critical thinking. They don't want well-informed, well-educated people capable of critical thinking. They're not interested in that. That doesn't help them. That's against their interest. That's right. They don't want people who are smart enough to sit around the kitchen table and figure out how badly they're getting fucked by a system that threw them overboard 30 fucking years ago. They don't want that. You know what they want? They want obedient workers. Obedient workers. People who are just smart enough to run the machines and do the paperwork and just dumb enough to passively accept all these increasingly shittier jobs with the lower pay, the longer hours, the reduced benefits, the end of overtime, and the vanishing pension that disappears the minute you go to collect it. And now they're coming for your Social Security money. They want your fucking retirement money. They want it back so they can give it to their criminal friends on Wall Street. And you know something? They'll get it. They'll get it all from you sooner or later because they own this fucking place. It's a big club, and you ain't in it. You and I are not in the big club. By the way, it's the same big club they use to beat you over the head with all day long when they tell you what to believe. All day long, beating you over the head in their media, telling you what to believe, what to think, and what to buy. The table is tilted, folks. The game is rigged, and nobody seems to notice. Nobody seems to care. Good, honest, hardworking people, white collar, blue collar, doesn't matter what color shirt you have on. Good, honest, hardworking people continue. These are people of modest means. Continue to elect these rich cocksuckers who don't give a fuck about them. They don't give a fuck about you. They don't give a fuck about you. They don't care about you at all, at all, at all. Yeah. You know? And nobody seems to notice, nobody seems to care. That's what the owners count on, the fact that Americans will probably remain willfully ignorant of the big red, white, and blue dick that's being jammed up their assholes every day. Because the owners of this country know the truth. It's called the American dream, because you have to be asleep to believe it.
George Carlin, one of the greats in this country. And earlier today, I was looking at that and thinking about what we're going through here in the Senate right now. You know, before it all started, many friends of mine said, I don't even know why you're bothering. You know that the Senate is partisan and it favors the Republicans. This is going to require a 2/3 vote. Something like 20 Republicans are going to have to step up, you know, for this to happen. And the feeling from the beginning of this has been against it in such a kind of tricky way. And I don't know, you know, I've been watching it here, and I don't know if you've been watching. I know you haven't been watching it with me, but I mean, maybe later you could check it out. I do think there are principles involved here that are much larger than the question of this Ukraine situation. I mean, the right wing is trying to convince me now that Biden was involved in something and that the entire intelligence community was being used by the Democrats to hide something. And I just find that the architecture of that is just so elaborate. It reminds me of what people say when people give you too many details, you know they're lying, right? It reminds me of that in a lot of ways. We're on a break from the Senate until 4 o'clock. That's in about 15 minutes. We are covering the Senate impeachment trial of Donald J. Trump. I am Karthik Rajan. We just listened to some George Carlin. And I thought we'd just put some tunes on and relax a little bit. The other thing to do would be to shut this down and then pick it up again as a part 3 in 15 minutes. That's probably a better idea. So we're going to do that. We'll start up again in about 15 minutes.